Welcome to the Real Estate Majlis podcast, where we dive into the latest real estate insights and trends. Whether you are a seasoned investor or a first-time buyer, our podcast is here to provide valuable information and expert advice. This episode is powered by Bayut, the UAE's leading property platform and proud member of the Dubizo Group. Whether you're buying, selling, or renting, Bayut connects you with real estate solutions tailored to your needs using innovative tools like TrueCheck, TrueEstimate, TrueBroker, and Bayut GPT. From finding your next home to advertising your listings with confidence, Bayut offers real photos, real prices, and real properties, helping you make informed decisions in the market. Welcome to a brand new episode of the Real Estate Majlis podcast. And I have my co-host, Mahmoud Al-Burai. And Mahmoud, we got, after popular demand,
Arash is back.
Arash Zad, top lawyer in Dubai.
Thank you. Thank you so much for having me. This is the second time, right?
Second time, because the questions keep coming about real estate law, and you are the top guy in the UAE. So obviously, thank you so much for coming. I really appreciate it. So let's dive into it. Sure. Obviously, you've been in the market for over 20 years. If you had a wish list of things you like to change that you think would benefit buyers or sellers and the dynamics of the real estate industry.
Like the magic wand, right?
Magic wand, yes. Let's start with the wish list.
My biggest concern is mainly securing the deals between buyers and sellers on the secondary market.
Yes, secondary market, the MOUs, right?
The MOUs or format.
Yes, tell me about it.
A huge number of people in different circumstances that they back out of the deal. There should be something to secure that and avoid these type of freedom to walk away. My suggestion would be basically for both buyer and seller to have some sort of guarantee in place, not just a security deposit that cannot be even handed over unless if there is a judgment. So they can create an escrow account for both buyer and seller. Both of them will put 10% in that account. No one can touch it. And then seller can not easily walk away because they know that they have their 10% involved. Additionally, as an extra layer, I would also recommend that the property gets blocked in case of a dispute. Right now, the property is blocked in Dubai Land Department only during the validity of the Form F, which normally nothing happens or nothing goes wrong at that time. The problem arises when the MOU gets expired. Yeah. That's the time that one party has defaulted and did not do the transfer on time. Then when the other party wants to, or mainly the buyer wants to file a lawsuit, the biggest question is always this. What if the seller goes and sells the property? Can we put a block? Obviously, no. There are ways to do a precautionary attachment or anything as such, but the chances of that are quite low.
Yeah. When it comes to buyer side, when they back away from deals, sometimes they back away for valid reasons, like I could not get a mortgage from a bank. So in such scenarios, sellers may have waited like 2 months and they lost in terms of time and maybe opportunities. So how do you deal with this when there's a valid
reason?
Yeah.
Everything goes back to the terms and conditions of the Form F. Obviously, the Form F is a ready template, but the additional terms and conditions that brokers normally, they prepare that, which I believe lawyers should do that.
Yeah.
The terms and conditions for a mortgage buyer should be explicitly clear and binding. There should be no room for misinterpretation, and it should clearly define different scenarios, what will happen if such and such event that perhaps was, as we discussed earlier, problem in the evaluation, delay in getting the approvals, final changes. So many things could go wrong in a mortgage deal. When the seller is agreeing to sell their properties to a mortgage buyer, they already know that things could go wrong, basically. But what protects them? Clear clauses in the agreement.
I got a case like someone came to me and they said they bought an off-plan property, but using mortgage. Everything was fine. Even the bank was fine. Then the master developer/developer did not give them an OC. So in such scenarios, when there is such like a blocker from a player, it's not the buyer, it's not the seller.
So the default should not be attributed to the seller or buyer directly. It could be due to a third party. Normally, there should be a clause where it states that if the problem comes from a third party, none of them should be at risk of being penalized.
The Form F expires and the deal is not done. In such scenarios, is it automatically renewed or can you back away from the deal?
So at the end of the day, we put a deadline and expiry date in the Form F for a reason, right? So if we are not supposed to respect that date, why do we put it at the first place?
Yeah.
So both parties should make their utmost best to
Meet that date.
to comply with their contractual obligation during the validity of the agreement. Now, in certain scenarios, we are not in an ideal world, right? Things could go wrong. But if both of them have the intention to continue with the deal, then they can renew it amicably. But if one party does not wish to continue, then the Form F cannot be renewed. So basically, the deal is over.
And you can go and get another buyer.
Yes, the agreement is not valid anymore.
And then the broker will be in a situation to whom I hand the 10%. Because if the two parties are okay, then it's fine. But if one party say, no, I want the deal, he backed away, I need the 10%.
The broker has to keep the check with them for the reason that that party could basically go to the court.
Yeah.
And then they will be liable why they have released the check.
But, I want to go back. I want to consolidate all those questions with your practice, right? So in reality, if you were to tell cases, because you do a lot of dispute on Form F and MOU, what are the cases, examples you witness that you see is recurring? And on top of that, when it comes to the security deposit, for example, that you mentioned, right? Do you actually get brokers giving the security deposit away to the
Some
party?
unprofessional ones, yes.
You've seen it.
Yes, there are some unprofessional brokers. They just got licensed and they open their company. They're not familiar with the regulation.
So they just say, "Oh, sorry, you default," and they're the
and
judge.
then
They become the judge.
Yeah, that will cause a huge problem
Of course.
for the other party.
Yeah.
Of course.
But from your practice point of view, when you look at the cases, do you see any particular recurring thing that you say, "Oh, this happens all the time. Here we go again."
Two things. Number one, which is I think the majority of our cases, is that because of the change in the price, the seller backs out. They become greedy to go and sell the property to someone else. That's the number one for us. The number two is miscalculating their financials from the buyer's side, that they think they may get certain amount of money on time and then they just rush into buying a property, signing a Form F, not knowing that things could not go as per the plan, and then they will have problem. When the transfer date comes, they don't have the cash, and then they'll have the problem.
And if you have things like as well with valuations, right? Because sometimes valuation does not meet the price of the agreement, and people sometimes they're not prepared to pay the extra. It tends to go lower most of the time.
That's why we normally draft a special clause just for the evaluation, that in case of the evaluation does not meet this percentage, then he can walk away without any penalty.
Yeah. And does normally buyers have a time period to when a seller is, needs to wait for their fine offer letter to come in?
It has to be practical.
Right.
So you can put a deadline. Say, for example, if a contract is drafted very well, so you would set timestamps, meaning we are signing on this date. You have 15 days to provide your offer letter. And then I have 15 days to do XYZ. If those time frames are there, then you can hold them accountable. Otherwise, it has to be logical, meaning, so if you have given 2 months time and then both parties have mortgages, then the first party cannot just wait, do nothing, and then expect that, all right, 1 day before the expiry date, I'm going to give my offer letter. It doesn't work, right?
Yep.
Because they know that the seller has also a mortgage.
Yep.
So this needs to be
cost
dealt.
them also more money.
Exactly. And they will not meet the expiry date. My highly advice is always draft the agreement in a way that you basically tackle all these issues.
Yeah.
That's why I'm saying
all
real
the
estate brokers
scenarios.
cannot really handle this terms and conditions because they don't have, most of them don't have the legal expertise to know what could basically go wrong.
And a lot of the times the addendum is also clashing with the Form F.
Which is not supposed to.
Yeah.
Yeah, it shouldn't be the case. Usually the Form F, they say add clauses as long as it doesn't
Contradict, yeah.
Let's talk about developers
Yeah,
now.
that's the interesting part.
Yes.
A lot of people bought off plan, right?
A lot of off-plan sales. The transactions are incredible. Obviously, the UAE have different jurisdiction when it comes to real estate in Dubai, Abu Dhabi, and so on. But again, if you have to give an advice to a first-time buyer who wants to get into off-plan, what would you like to share in terms of they should be watching out?
Make sure that they are dealing with the right developer. A reputable developer who have a history of delivering successful projects. That is their resume, right? Now we have lots of developers. They are most probably registered with Dubai Land Department as well, but they're new. So chances of them not being able to fulfill their obligation or complete it or even deliver the same quality that they have promised are, chances are quite high. But if you are dealing with big names, reputable developers, those risks will be reduced significantly. So dealing with the right developer, dealing through the right broker, a real estate agent that you are dealing with, they should be professional enough that they will show you around, introduce you to the right people, introduce you to the right project, understand your financials, because deals are very, very interesting and promising.
Yes.
So people get emotional. The moment they get emotional, things gets out of control. And that's where they get excited and they rush into buying something. They go to buy a one-bedroom apartment, they'll end up buying a townhouse, right? Because it was explained to them that you don't need to pay that much now. You just pay 10% now, or perhaps the biggest part is post handover.
You can sell it before.
Yeah, so they rush into it. And a lot of promises, yes, you're right. Promises that just buy now, after 3 months, I can sell it for you with 40% increase.
Yeah.
The contract from the developers are really non-negotiable. And in fact, it's getting more and more, like Abu Dhabi now is being standardized. So you can't really ask them to add something that you feel might make you feel better by buying, and it's so fast, the market, that there's not much room there for that side, which obviously then creates a situation that things are really one-sided, right? From a developer point of view. And then you get into situations like handovers, right? So you talk about working with reputable developers, right? There's a lot of developers do not meet the criteria, the minimum criteria of you can delay up to X amount of months or 1 year without any penalty, right? And sometimes they go above that. Or sometimes when you measure your unit, the unit comes in slightly, maybe 10% smaller than what was in your contract, right? So how do buyers navigate things like this?
A lot of people ask me the same question. If the developers will never change the SPA, why do I need to even bother reading it or giving it to a lawyer to get their opinion on it, right? The answer is very simple. Let's assume that they are not changeable, which I know it is in some occasions, depending on the offer that you're putting on the table, of course.
Yeah.
At least when you read the agreement, you would understand the scope of your liability. If you see the way that you mentioned, that this agreement is drafted one-sided and they are not considering the investor side, don't buy from them. You are not forced to buy from it's a single developer. So if you are not comfortable with the agreement, that's the biggest red flag. It means that this is not the right developer, at least for you, because my flexibility or my tolerance for risk, it at a certain level. If I read the agreement and I see that this exceeds that limit, it means that this developer doesn't work for me. I'll go and find another property, another project with another developer, which has a much better and more fair agreement. As simple as that. This is where people don't realize. Because they got emotional with that project, they've been sold to that, you have to buy from this. No, not necessarily.
But a lot of time, Arash, what happens in reality is that initially you do the initial booking, you commit, you give money, 5%, 10. Then the SPA come to you 2 months later
And then you're
you're
shocked.
stuck, you cannot get out.
Yeah.
So, and that's a question a lot of time we face is that maybe you can ask for SPA
A
because
template?
before even signing
Yes,
it,
of
how does
course.
it look like and what are the liability as you correctly
Absolutely.
said. But even the question on the escrow, maybe that's another remark for people to watch for, is that a lot of people, when they buy from off-plan developer, they assume it's whatever bank account is giving them is the right one. So what's the advice we have here, especially in the initial stage of
Unfortunately,
payment?
this is a big problem now because people. The good thing about Dubai is very trustworthy. They have set the rules and regulations in a way that deeply protect and think about the investors in order to encourage people to come and buy properties. But it's exactly the same scenario as you keep the engine running and you leave your car and you go to the supermarket, right? It's a safe city, but you're not supposed to do that. That's why you're going to get a fine if you do it now, right? The same thing applies to people when they are buying properties. You should not assume that, okay, since this city or this country is safe, you should close your eyes and just deal with someone. And whatever they tell you, just do it. There are developers that there is a possibility that they are not practicing everything as per the book.
Yes.
Number one, maybe they are not registered with Dubai Land Department. Number two, maybe their SPA is not registered and got approved. Number three, maybe they don't have an escrow account. So the best way to identify this, go to the Dubai Land Department's website. Make sure that they are a registered developer. Make sure that they have already introduced an escrow account. An escrow account will not be the name of the company, will not be the name of the developer. It will be the name of the project. Nothing else. If you see the account holder is the company, run away.
Yeah.
That's the thing you should be
And
careful
I've seen
of.
situations of deposits being paid to the company corporate account rather
Yeah.
than the escrow
Many
as
of
well.
them.
Which is in violation of all the laws.
Absolutely.
Usually the escrow account has the word escrow at the end. So you'll say this project, usually it's a project name, and then it has the word escrow.
Yes.
At the end.
So
Yes.
and the best way is you should go to Dubai Rest, right? And in Dubai Rest, you go and write the project name. If it's there, this means it's approved.
Yes.
Then you go to the bank. This is the same account they give me or not.
Cross-check it and then make the payment.
Yeah, and then make the payment.
Continue on the developer conversation. When it comes to the milestone payment and construction update, right? Sometimes there seems to be, some developers use the construction milestone based on a date, and some of them based on construction, like slabs, second floor, third floor. Is there something customers should be looking at in the Dubai market to what is a red flag on the contract? And equally, when it comes to, for example, paying an installment, let's say you have to pay now 50%, but the RERA certificate shows the project is at 5%. Does that give you the right to say, sorry, until you reach that percentage, I'm not going to pay? Is there any room there for buyers to be aware or seek legal advice at that point?
What I would always say, again, we go back to the agreement. Make sure that you understand your agreement. You know what is your obligation when it comes to the payment terms. And the ideal scenario is always payment terms or payment plan should be linked to the construction level. This is the safest, the healthiest way. And the reason is that if the project has been completed up to 80%, 70%, there is a value there.
Yeah.
There is a value. So even if this project or this developer runs away due to any reasons, there is value there on the ground. The government will take over. Another developer might be interested to take over. They will purchase the project and they will continue. But if you have paid 70% while the project was completed 10, 15%, what value is there?
But you can, as a buyer, say to the developer, I'm going to only continue until you reach certain percentage.
If they have agreed with the payment plan and the agreement, how they will have the power to stop paying. You have agreed with that term. So this is the same thing. We have a law to protect people. But if people are not aware about it
And
and they
agree
don't
something else.
practice that law, how the government or the judicial system can protect you.
Yeah, the good thing that always happens is that when there's a discrepancy between what's being constructed and what's being paid, usually developer will go to the Land Department to cancel the buyer from the system. So
if they default,
Yeah, so Land Department does a smart thing when they say you haven't constructed enough, so you cannot cancel this contract.
But do they do that always?
I've seen a lot of people who went through the same experience. So if the project is not progressing on ground, the probability of canceling investors is less. It takes time, and usually investors go to Dubai Land and start talking about, we want to reschedule our payment, link it to construction. But as you said, a lot of contracts I've seen as PA, it's dates and times. It's not construction.
Yeah.
And that's really, if I see such contract, I will not sign on it myself.
Exactly.
I will not buy a property that is linked to timing.
This could be also one of the changes which you asked at the beginning, right?
Yeah.
It should become mandatory for all developers to link the payment plan to the project, the construction level. It's a beautiful thing. Automatically secures the investors big time.
Any more developer questions? Should we move to leasing?
To leasing, because that's also very interesting with the increase in prices, and a lot of landlords want to evict tenants, right?
That's true. The idea of increasing, so this is one of the things that changed a lot recently. Initially, we had the RERA calculator, which we still have it.
Yeah.
At one point, we had an extra or an alternative way, and that was appointing an expert to do the evaluation. The reason that this came into play because the rental calculator was not getting updated on regular basis.
And you had all variations as well for townhouse size and
that's true.
pool, not the upgrades.
Yeah, perhaps a project got upgraded in the middle of old other projects, and it was not fair for them to ask for the same and similar to the other projects. So the expert came into the action, and that was amazing in my opinion. So I think you could have used this service by going to REST app and just pay 2,000 dirham, an expertise report, and it comes to you. It was amazing. But then all of a sudden that got stopped. They said that no longer is practicable, and then you have to go to the court, to RDC. So now we still have that option, but it's a bit more difficult. And the reason is that you need to file a case at RDC and then ask the judge to appoint an expert to evaluate the property. And then only the expert will give the evaluation, and accordingly you can ask for the increase. Otherwise, the rental calculator is a place to go. Check if it's possible to increase, you go for it. But the way that you can ask for that increase is to send a legal notice through the official channels, which is either the registered email on the lease agreement, registered post, or through the notary public.
3 months before.
3 months prior to the expiry.
Otherwise, you cannot increase.
Absolutely no.
Yeah, that's a lot of time. Tenants call me and they say, the landlord asked to increase 1 month before the expiry. I say, he doesn't have a case.
Exactly.
So the timing is important as well.
Yes, absolutely.
3 months, always.
That's right. Yes.
Unless agreed otherwise.
Yes.
But usually it's 3 months.
The judge will not accept if it's even agreed on.
Okay.
The law is clear. 3 months, you have to give notice.
And I think the other thing that there was a lot of change historically is the eviction, especially when the property is sold, right? Where sometimes you have, where the property changes to a new owner, in the meantime, you have to serve a new notice of eviction, but now that eviction needs to carry forward. How does that work right now? Because it keeps changing.
That's a good question, because that's still the gray area.
Right.
Still, we cannot say 100%, but now the practice is like this, which unfortunately, a lot of brokers, they are giving the wrong information to the investors, and they are facing problem because of that. Based on those promises they are buying, but then they will see that the reality is different. For example, if the current owner or the old owner is giving a legal notice, eviction for selling the property, after 12 months, basically the tenant has to leave the property. Now, if in between this period of time, the seller is able or the owner is able to sell the
Sell
property
before.
to someone else
Yeah.
before the 12 months, the question was, can he use the same legal notice?
The new landlord.
For the tenant. The answer is yes, but only for the same purpose that the first legal notice was served.
Oh, hold on. No, I was getting
Meaning that if he said, I'm selling the property, you need to leave the property after 12 months, the second owner, if he wants to also sell the property after a while, he can use that legal notice. But if he wants to rent it to someone else, that legal notice is
But
not
if he wants
acceptable.
to
Personal
move
use.
in,
That's fine also.
so personal use is fine, which
Yeah.
makes sense. And then
Yeah.
So you cannot rent it out to someone else.
No.
and this is what you're
but-
saying about the brokers.
but
They get it
again-
wrong because they tell, oh, let's buy this unit. We'll take the current tenant out, we'll get you a higher rent, and then off you go. No, you can't do that.
It doesn't work anymore. And
That's
again,
good to know.
what I'm saying is the common practice, but there could be judgments which contradicts this.
Right.
So I
So
don't
it's
want
not
to give an
100%.
opinion on this that is 100% bulletproof. No. But
People
this is
should
now
be
the
aware.
main. Yeah, if you are buying a property for your personal use, buy an empty property. Don't buy a tenanted one
If you want
because you cannot guarantee
guarantee.
unless if you willing to wait for 12 months and then only move in.
What's your advices to tenants when they, or to landlords as well, when it comes to tenancy contracts, what they should be looking at in terms of clauses in the contracts?
My general advice is this. First and foremost, understand your rights and your obligations according to the law, not just what you've been fed by the brokers or people around with no expertise. Understand exactly what are the laws that protects you and what are the laws that are against you. When you know those laws, and it's very simple, they are not like very difficult or complicated. No, they're simple. If you understand that, you would know what to search for in your tenancy agreement. And if you feel that you don't have the expertise, that's where you can go to a lawyer.
Yeah, especially disputes. A lot of time we see disputes on maintenance, energy cost, who pays what. So we always tell tenants, make sure that you see who pays what when it comes to running cost of property.
Oh yeah,
who
especially
pays
on villas, right?
Yeah.
Especially older villas. They put
Yeah.
a clause always saying it's 1,000 dirhams, 3,000. But what?
That should not be there,
Yeah.
right? What they can put is, in my opinion, you need to be as detailed as possible. Just go to as much detail as you can. Just list them, or have it annexed to the agreement. Have a separate page. These are the possible expenses and charges, and we define exactly who pays this, who pays that. As simple as that. Then there will be no dispute, basically.
Arash, tell us about a case. Share with us a case that it was different than the outcome, and something that you feel will be good to share with the audience.
Of course, because of the confidentiality, we cannot
Of course.
go too much into details. But one of the interesting matters that saved my client millions of dirhams was this, that a client of mine who was a bulk investor, he was offered to purchase a full tower, or half of it at least, and the project was just launched. My client immediately got super excited because he received the first offer, and it was a very, very good opportunity. And this conversation is long ago, not now. Yeah. You've been in the market for long, I believe, Dr. You as well. So you might know about this project. But anyways, when the client contacted me, he said that, Arash, everything is done. I'm going there. I'm going to sign the MOU, and I'm going to put down the check, and I'm taking over this project. I want you to come with me. I said, but did you do everything, all your investigation, due diligence, everything is done? He said, yeah, everything is done. I'm just going there to sign it off. He said, I want you to come and oversee everything and make sure that everything is as per the book. I said, I will come with one condition. I said, what? If I tell you walk away, you will walk away. No questions asked. he was so confident that
This
he
is not
thought
gonna
that
happen.
this deal is bulletproof. Nothing could go wrong. Definitely, Arash will not tell me to walk away. He said, okay, agreed.
Yes.
We went there. It was I never forget that. It was a room, 3 of us, 10 of them. They came with all the people and they said that here is the agreement. And my client immediately wanted to
Sign.
take the agreement and sign it. I said, guys, 1 second,
Wait.
please. Can I see your ownership documents? You should have seen their faces. First of all, they got offended
Of course.
because people at that level,
Yeah.
they were not expecting me to, question their
The
ownership.
basics.
I said, I need to see some ownership documents. And then I felt that my client is also getting a heart attack. They said that we will provide you with those documents, everything, we will send it to you, but after you sign and you put the
MOU,
deposit,
yeah.
because of the confidentiality, we cannot share more information. I told my client, let's walk away. It was very difficult for him to accept, but he did. And then later on, we realized that they had problem in the ownership. The land was granted. And, a granted land, you cannot
can't just
sell.
sell, yeah.
So they were launching a project on a granted land with the hope to get the approval to convert it and be able to sell.
Wow.
And then later on, that permission was not given and they had to cancel the project. He could have lost millions because of that.
Amazing. Any more questions, Mahmoud?
Mashallah, he nailed it. Arash.
Arash, it's
you,
always
guys.
a pleasure to have you with us.
Pleasure is mine. Thank you for having me.
I'm sure a lot of the audience have enjoyed and got clarity on a lot of important points because the legal aspect people take for granted. And again, we're such in a transactional market right now that people just sign everything without reading. And the importance of lawyers, especially who specialize in real estate, is very important at this time. Not everything's bulletproof. So
Absolutely.
wish you all the success and thanks for coming again.
Thank you so much.
Thanks,
Thank you,
Arash.
guys.
Thank
Thank
you.
you.
Bye.